Hello, this is Ifama Udalami from the Udalami Law Firm, and I'm here today to go over conditional green cards. And I just want to wish everybody a happy July 4th. I hope you all had a great July 4th celebration. We did. And I'm really excited to talk to you guys today. We've had a really great immigration lawyers and immigration and humanity. We've had a really great couple of weeks from the federal court decisions. First of all, we had the decision that reinstated DACA after the Trump administration had removed it, which was a great win for us. We had the third country asylum rule, which now says that the Trump administration requiring people who are seeking asylum to seek asylum from a third country that they came through is illegal. So that's really great. And then we just got another decision saying that the children in detention should be released because of COVID-19. And so that's really great. Immigration lawyers are, in a tizzy because this is what we've been fighting for, and it's really great that the federal courts are seeing that the administration has been making rules that are quite inhumane. So today I'm going to talk about conditional green cards. You know that when your spouse files for you and you get a green card and you've been married 2 years or less, what you get is a conditional green card. And what that means is that you have to remove the conditions on the green card before you can get your permanent green card. So typically you're required to remove those conditions 90 days before the expiration of the green card, and you can figure out when the green card expires by looking at your green card. So you're supposed to remove the conditions with your spouse. You're supposed to file the I-751 form, and you're supposed to provide USCIS with documentation which shows that the marriage is bona fide. Now, the information you're given USCIS is proof of a bona fide marriage from when you got your green card to the present. So you don't want to give them the things you submitted to get your original conditional green card. You want to get the things that are updating them with regards to how to the legitimacy of your marriage. So you want to show them updated information with regards to your finances. Have you bought a new house? Have you moved? You want to show them updated information with regards to pictures. Where are you vacationing? What are you guys doing together? And if you have children, of course, in the interim since then, that's excellent. So now, sometimes happily ever after does not last. People find that by the time it's time to remove the conditions, the marriage has pretty much packed up. So I want to tell those people that you do not have to worry because there are 4 waivers that you can rely on to get your green card. So these are waivers to the joint filing requirement. The first waiver is a divorce. If you're now divorced, all you have to show is that provide evidence that the marriage was bona fide in the first place, and then provide a copy of the divorce certificate. And that's why last week I did a whole topic on presenting evidence of a bona fide marriage, because the linchpin of many benefits that you get through in immigration through a spouse is showing that there's a bona fide relationship. So that's really important. You have to be able to show that the relationship is real and it was not entered into for solely immigration benefits. So a divorce is a waiver to getting your spouse to jointly file to remove the conditions. You can also file if your spouse, the U.S. citizen spouse, has passed away in the interim. You can also file by showing the death certificate, and also by showing proof that it was a valid relationship while he was alive. And the third way to get a waiver from the joint filing requirement is to provide proof of abuse. If you've been in an abusive relationship, you want to show proof of that. Now, USCIS does not require you to have a perfect marriage. You're not required to stay in a bad marriage because you want to get a green card. So if you're in a relationship where you're being abused, and abuse doesn't have to be only physical, it can be emotional, it can be financial, it can be verbal, it can be sexual, it can be psychological. All these types of abuses, which in my other videos we've talked about, are, if you can show proof of them, you can get a waiver to the joint filing requirement. And the fourth waiver is the extreme hardship. And I have to tell you, that one is a little hard to get because you have to show that being deported or sent back to your country is going to be an extreme hardship to you. And the hardship they're looking at is a hardship from when you got the green card. So that one's a little difficult to get, but that really works usually when you have, maybe there's a war in your country, or there's something going on that you can't go back. So those are the four joint requirements, the four waivers to a joint filing requirement. Now, sometimes you try to remove the conditions and you're still denied. And when that happens, most of the time you're going to get an NTA, which is a notice to appear in immigration court. That's the beginning of deportation proceedings. And a lot of people get, they get scared. Does this mean I'm going to be deported? And I want to tell you, no, it does not mean you're going to be deported. It does mean that you have to work your case and, provide evidence that there are reasons why you should not be deported. Your case is now before immigration court, but there are several ways to go through to get your green card, even if you're in deportation proceedings. And I've talked about this so many times. I've talked of VAWA being one of the cases where you can still get a green card. So if you can show that your relationship has been abusive and you're married to a U.S. citizen or a green card holder, even if you're in immigration court, you can still get your green card. Of course, you can file the VAWA petition in Vermont. The judge who is presiding over the case in the immigration court will rule on the adjustment of status. So sometimes we have people who are in a relationship where they're supposed to show up for the interview to remove their conditions, and the spouse doesn't show up because they're having a fight. And even if that happens, you can still get your green card if that spouse is willing to show up again, basically show up for you. Maybe it was just something that happened and everybody was angry and he or she didn't show up. You can refile the I-751 if he will jointly file with you to waive the conditions. And if that spouse does not want to do that, there are other ways that you can get your green card if you qualify. So typically what my office does is we look through what's going on. We invite you to contact our office, 973-993-1900. We're in New Jersey, but we take cases from New York and all the other states in the United States because immigration is federal law. And we will, check to see if there's any other qualification that can allow you to get your green card. So I'm going to make this short because it's, I know everyone's still getting over the holiday weekend. So I don't think I have any questions. So I will sign off. And if anybody feels that there's somebody who can benefit from this video, please feel free to share. Again, my office number is 973-993-1900. Thank you.